In the name of God, the compassionate, the merciful. Welcome, friends, to the 73rd episode of Crime and Punishment, a legal podcast, not a political one. The official podcast of the Invictus Law Firm, PA, a criminal defense law firm in Orlando, Florida, the website for which is augustusinvictus.com, and that is me, yours truly, the host of this program. We are absolutely not talking about politics today. We are only talking about the law. We are not going to talk about the shooting that happened yesterday, or the identity of the shooter, or how they identified. We are not going to talk about Trump's speech this weekend on the 30th anniversary of the Waco raid by the FBI and ATF. We're not going to talk about any of that, because here at Crime and Punishment, we only talk about the law. We're going to continue our discussion today about the basics of criminal law. We left off last week with lamenting the Patriot Act and how it completely destroyed the Fourth Amendment and America, by the way. Today we're going to continue in the same family legal guide published by the American Bar Association, our favorite association of lawyers. And we're going to start with whether the police can search without a warrant, which we've talked about several times on this program. Just checking Twitter before we begin about the FBI and ATF. News is going off on them right now. Certainly not because of politics, only because of legal things. So let's get on with it, shall we? Question: may the police search me without a warrant? That depends on whether you are under arrest. No, it doesn't. Well, let's continue. If the police have lawfully arrested you, they are permitted to search you. They also are allowed to search the area under your immediate control, also known as your wingspan. Oh, we've already talked about that last week. There you go. Greetings, Jimmy from Orlando. Odysseus, we're going to have to shushy. Remember? Yep. Odysseus is in Daddy Academy now, up until he starts kindergarten, so that's a long time. Let's talk about admissible and inadmissible evidence. What does it mean if evidence is admissible or inadmissible? If evidence is said to be admissible, it simply means that it can be admitted into evidence and relied on in court. If there is some problem with the evidence, it was procured unlawfully, or it is likely to be unreliable for some reason, hearsay is the example they give, then a judge can rule that it is inadmissible. This means that it cannot be relied on in court when the case is being argued. For example, if the police seize drugs, but they seize them by means of an unlawful search, the drugs are inadmissible as evidence. That's the basic answer, and yes, technically, let's say that's true. But as we said last week, the correct answer is always, it depends, right? We have, as I complain about all the time, this 1,000-year legal tradition, this Anglo-American legal tradition. Our entire civilization depends on it. And we have done everything we can in the past 60 years to just completely throw it out the window. Certainly the last 30 years, since the Clinton administration. But let's talk about hearsay, for instance, right? This is one of those rules of evidence that we've been developing for centuries and centuries. If you come into court as a witness and you say, person X said blah, 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 you can't say that. You have to bring in that person who allegedly said it and have them testify to it. You know, there are certain exceptions to that, but generally speaking, that is hearsay. To say, well, Johnny told me that blah, 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 or Johnny said X, Y, and Z. You can't do that. That's inadmissible. You would have to bring in Johnny and ask Johnny what happened. Generally speaking, even Johnny couldn't say, well, I said X, Y, and Z. I said blah, blah, blah. That's still hearsay because you are presenting it for the truth of the matter asserted. We're getting rid of that. Getting rid of a lot of that. Can't get rid of it fast enough, especially in cases involving women. Hashtag believe women, domestic violence cases, all these rules of evidence just disappear. Rape cases, sexual assault cases, anything that involves women as an alleged victim, we are throwing out all the rules of evidence as fast as possible. Whereas it might be relevant, someone's history in a certain case, if they're a woman, a sexually promiscuous woman, by law that is now irrelevant. I happen to have experience with one particular case where obvious hearsay, everybody knows it's hearsay, recording of a woman making false allegations, judge allows it in anyway because, well, I'm going to throw the prosecutor a bone. Forget all those 1,000 years of evidence rules we've been developing. So this whole myth of the rule of law, once you actually practice law, becomes very apparent. This line between admissible and inadmissible evidence, we pretend that it's black and white. Really, it's up to who's arguing the case and what did the judge have for breakfast that day. How does he feel about this case? I won't go down that rabbit hole. Let's see. Whether the evidence was procured unlawfully is one of the things that the ABA addresses. So they're saying, for example, if the police seize drugs, but they seize them by means of an unlawful search, the drugs are inadmissible as evidence. Or for another example, if the police search a kid because he was putting up flyers and those flyers offended people, and they search without consent, and they search without probable cause or a warrant, in that case, whatever they find, whether it be drugs or a pocket knife, that evidence would be suppressed. It would be thrown out because it's the fruit of an illegal search. That is inadmissible evidence. And in many cases, once you have the actual evidence thrown out of the case, that case has to be dismissed because there's nothing else to prosecute on. However, there's also the loophole here that cops, that feds often use, and that's, well, we didn't procure this evidence illegally. The confidential informant did. We didn't tell this third party to go get this illegal evidence. They just had it and they gave it to us. Nothing we can do about that. Well, that's going to be admissible in a lot of cases. So if, for instance, a confidential informant, or to be more charitable to the police, just some random citizen breaks into a guy's house and finds, I don't know, the nuke codes, right, and gives it to the police are going to say, well, we didn't break in there. That guy broke in there, and he gave this information to us, and we acted on it. And that would be legitimate. There are, however, plenty of instances where the cops know full well what their, little dog is doing. They let them off the leash. They let them engage in illegal activity. And the question is always a gray area. Well, did you order him to do this? Did you know that he was going to do this? Or did you just look the other way? But police often use illegal activity by third parties to make that evidence admissible. And then you have the nefarious cases of groups like Verizon, Facebook. Now we're all looking at TikTok. All these third parties, these private companies who will just hand over your information to the police. Well, police didn't search it illegally. Your company gave it to them. And the company that you paid for that service gave it to the cops. Nothing illegal about that. Don't like it? Make your own phone company, right? I don't know if you all saw the drilling in Congress of the CEO of TikTok. But I don't remember them having that kind of testicular fortitude when they were interviewing Zuckerberg or Jack Dorsey. They're pretending that they're morally outraged about TikTok having all this information on American citizens. None of that moral outrage was there when they found out about the Twitter files, when they found out about what Zuckerberg was doing. None of that moral outrage is there when they find out Verizon and other companies are giving your information over to the feds and to police. No subpoena, no warrant, just, we're happy to cooperate, officer. So that is typically going to be admissible. And then screw you. You don't like it? Make your own company. Does the law permit the police to search my home or items in it? I feel like we read this last week. You have greater rights at home than you do in your car. That is because the courts have decided that the law entitles people to greater privacy rights in their homes. Therefore, the police normally cannot search your home unless they have a warrant. The warrant must specify what the police are looking for and the specific areas of the house they are allowed to search. The police may search outside those specified areas in some circumstances, for example, to prevent the destruction of evidence or to ensure the safety of the police, which they rely upon regularly. So, for instance, we have exigent circumstances. Drug dealer is running away from the cops, runs into the house. Well, no matter how anti-cop or anti-system you are, obviously there really is a danger that the guy is going to flush the cocaine down the toilet, right, before the cops get there. Those are exigent circumstances. A warrant is not required. They're in hot pursuit. They can go in there and secure the evidence before it's destroyed. What was the other example? Oh, safety of the police. Yeah. Everything is safety of the police. Officer safety, officer safety. If I had a dime every time I heard the phrase officer safety in court, bro, I wouldn't be practicing law anymore. I'd be on a yacht in the Mediterranean right now. If the police do search without a warrant, the search is presumed invalid. So you have the right to challenge it in court. If the judge finds there was a valid exception to the warrant requirement, he or she will rule the evidence admissible. On the other hand, if there was no such exception, the exclusionary rule, which prevents illegally obtained evidence from being introduced at the trial, may prevent the evidence from being used against you. One exception to the warrant requirement is that the police do not need a warrant to search your home if you agree to search. That is consent. We talked about that last week. Do you really think I'd be stupid enough to tell the cops to search me if I had cocaine on me? Yes, I do. I do believe that because I have seen it happen over and over and over again because people in fear, especially if they're on drugs, think, well, I'll just get out of this later because I'll think, I'll tell everybody, do you really think I'd be that stupid? I'll just say the cops planted it on me, or maybe if they find it and I said, yeah, I'd let you search and they'll be cool with me, or whatever goes on in the mind of someone who's afraid and on drugs. Seen it a million times. People will routinely consent to a search when they know they have contraband on them. And it's like, well, I guess this is why I have a job. I guess that's good. But don't give consent to search under any circumstance. If they search you illegally, then that evidence will be thrown out. It will be suppressed. You can win the case that way. If you give consent to search and you have contraband on you, tough luck if they didn't have any right to search you. If they don't have a right to search you, then say no. And if they don't have a right to search you and they search you anyway, then it is an illegal search and the evidence will be thrown out. But if you give consent to search, they don't need any right. You just gave them the right by consenting. Consent must be voluntary and must be given by someone who has the legal right to be in the home. So, in other words, cops come to your house, Jimmy is visiting from Connecticut. Any resemblance of real persons is, totally accidental and should not reflect on any real persons. It's my legal disclaimer. So Jimmy from Connecticut's in your home, and the cops know he's visiting, and they know that you're out of the house, and they're after you, and Jimmy says, I guess you can search, I don't know, because Jimmy's a stoner, and he doesn't know, he doesn't listen to this program like you do. Well, the cops don't have a right to search the home. Jimmy doesn't live there. Jimmy has no right to allow them to search the home. One of the law school questions that they'll often give you is, well, what if there are roommates and the roommate says, yeah, you can search the house? Well, then they can give consent to search the common areas of the house. Like if Jimmy actually does live there, but so do James and Barbara, Jimmy can give consent to search the common areas of the house, like the kitchen or the living room or wherever everybody goes, and he can give consent to search his room. But Jimmy can't give the cops consent to search Barbara's room or James's room, right? So if the cops do that, and they try to use evidence that they find in that, that's an illegal search, and that evidence can be suppressed. Let's see. Obviously, you can give consent to search your home or apartment, but you are not the only person whose consent would be valid. Your spouse could consent, as could an adult child living in your home. It is important to note that in seeking your consent, the police are not required to explain the consequences. Yeah. So there's this myth that, this urban legend, if you ask somebody during a drug deal, are you a cop, they have to tell you. Otherwise, there's no arrest that can be made. Like, it's very explicit law. Cops are allowed to lie to you in an investigatory phrase. Cops are allowed to lie to get information from you. They are allowed to lie to make an arrest. Otherwise, there would be no such thing as undercover cops. There's a line, obviously, but they're not required to tell you the truth, and they're certainly not required to tell you the consequences of what's going to happen if you allow the search and you are caught with contraband. For example, they need not tell you that any item in plain view or found during a search, if it is somehow connected to a crime, can be used against you or any other member of your household. Consenting to a search may have unexpected consequences. The police may recover evidence you did not know was in your home or was linked to a crime. We talked about that last week when we said do not consent to a search of your person. All right? So do not consent to a search of your home either. Even if you do not agree to a search, the police are permitted to search your home without a warrant if there are sufficiently exigent circumstances. That's the one we talked about already. Like you're running, you could destroy evidence, so on and so forth. All right, let's move to the next question. May the police use information from a confidential informant against me? All right, short answer, yes. Question, what procedures must the police follow while making an arrest? Answer, the police do not have to tell you the crime for which they are arresting you, though they probably will. Can confirm, I was not actually told what I was accused of until I was extradited to South Carolina, like weeks later. So think about that. They are not permitted to use excessive force or brutality when arresting you. If you resist arrest or act violently, the police are allowed to use reasonable force to make the arrest or keep you from injuring yourself. It may be a separate crime to resist the arrest. And in fact, this is 2004, this is before the police state really exploded, or about the time it was exploding. They will arrest you just for resisting arrest. I've had a case or two where the only crime charged, the only crime on the docket, the only allegation was that the person resisted arrest. Unfathomable. Blackstone and Coke would be rolling in their graves. While the police are arresting you, they probably will read you your Miranda rights. They do not have to read you this rights if they do not intend to ask you questions. I've actually had that question before, right? Somebody gets arrested and they come to me and they say, well, the police never read me my rights, so can we get this case dismissed? And obviously the first question out of my mouth is, well, did they ask you any questions? No. Did they, ask you your name? No. Did they talk to you in the police car on the way there? No. They didn't say a word to you? No. You didn't say a word to them? No. So you didn't confess to anything? No. Well, then it doesn't matter that they didn't read you your rights. You're read your rights because they're going to ask you questions. Now, it would be smart of them to read you your rights anyway, even if they're not going to ask you questions, because if you start talking on the way, then you start confessing to the crime in the cop car, then they are going to wish they had read you your rights, but they don't have to. So the fact that you were arrested and they didn't read you your rights does not mean that you can have the case dismissed. It just means that if they don't read you your rights and they question you and you confess to the crime, they can't use that against you. When am I in custody? Good question. Answer. The most obvious example of being in custody, of course, is when the police say you are under arrest. But you might be in custody even if the police do not say you are under arrest. Generally, the law considers you in custody when you have been arrested or otherwise deprived of your freedom of movement in a significant way. This may occur when an officer is holding you at gunpoint or when several officers are surrounding you. Other examples are when you are in handcuffs or when the police have locked you in the back seat of a police car. There are no absolute rules on when a person is in custody. The test is whether a reasonable person in the circumstances would have felt free to leave. Free to leave the scene, and a court will consider all the circumstances. So, a reasonable person, if you are at a police station and you are in an interview room with two police officers, you're not handcuffed, the door is closed, and they're asking you questions, would a reasonable person feel free to leave? Who knows? It depends, right? If I were in that situation, and I know, as a lawyer, I can just get up and walk out of here, then a reasonable person might not think that I was in custody. Well, this guy's a sophisticated party. This guy is a lawyer. He knows that he's not under arrest. He knows he doesn't have to talk to the police, and he's sitting there, telling them all these things. He was clearly not in custody. In fact, they told him he could leave, and he knew that he could walk out. And he still talked, and he still confessed to this crime, right? Whereas a 16-year-old kid in that same position, 16-year-old is in an interview room, doors closed, two cops in there. His parents are not there. His parents don't know he's there. His parents have not given consent to this interview. Well, I think a reasonable person would say in that instance, this 16-year-old kid did not feel that he was free to leave. This 16-year-old kid was absolutely in custody, whereas the 39-year-old lawyer might not have been. So that's the test. Would a reasonable person in those circumstances have felt free to leave the scene? Question. After arresting me, may the police make me provide fingerprints, a handwriting sample, or a voice example? Answer. Generally, the police are permitted to force you to supply these. They will take your fingerprints during the booking procedure at the police station. The law considers handwriting samples and voice examples evidence of physical characteristics. Therefore, you may not claim that the police are forcing you to incriminate yourself through these identification procedures. The police may use these samples as evidence against you in court if they help prove that you committed a crime. For example, your handwriting may be compared to the signature on a forged check, or to the writing on a note handed to a teller in the bank robbery. Question. What are my rights if the police put me in a lineup? Answer. In a lineup, several people who look somewhat similar will be shown to victims or witnesses who observed the crime. The police will ask the witnesses if they can identify anyone in the lineup as the person who committed the crime. If formal charges have been filed against you, and the police put you in a lineup, you have a right to a lawyer present to protect your rights. A lineup is not supposed to be unfairly suggestive. That is, if the victim said her assailant was approximately 6 feet tall with a red beard, the lineup cannot include 5 short, clean-shaven, dark-haired men and only 1 tall, bearded redhead, right? So when they're rounding up people to do this lineup, they can't have 1 Dennis Rodman and then 5 Danny DeVitos and say, all right, which is it? Like, obviously, she's going to pick the tall guy, right? If that was the allegation. You can't do that. You have to pick people who are similar enough that this person can pick them out of the lineup, but it's not overly suggestive. Similarly, the police are not permitted to suggest to the victim that a certain person in the lineup is their main suspect. For example, they may not point to one person and ask, could that be the man that stole your purse? Neither are police permitted to make such a suggestion during photographic identifications. When a witness is asked to pick the suspected or accused criminal from 6 similar photographs on a card, the suspect does not have a right to have a lawyer present during a photographic identification. The suspect is not present at photo IDs. When you are in a lineup, the police have the right to ask you to speak if the witnesses feel they can identify you by your voice. The law permits the police to have you speak the words used during the crime. They might ask you to say, for example, "Give me your money." Well, let's go back to the ID thing, right? There have been cases where, the police will have the suspect and they'll take the witness and they'll take them to the person they suspect of having committed a crime. The person's in handcuffs sitting on the ground, and they'll ask the witness, "Was that the guy that broke into the house?" And human nature being what it is, the witness sees this person in handcuffs and says, "Oh yeah, obviously that was him. Yeah, I confirm that." That is improper. That ID could probably get thrown out. Because that, again, like the lineup with Dennis Rodman and the 5 Danny DeVitos, that's an overly suggestive ID. The police already have a guy handcuffed. It's one suspect. It's not a lineup at all. And they're saying, is that guy on the ground with the handcuffs that we just beat up, is that the guy that committed this crime? Pretty suggestive. Most people, it doesn't matter who really committed crime, if it looks close enough and it's a human being, they're going to say, yeah, that was the guy that did it. Question: what is an interrogation? Answer: an interrogation might be explicit questioning, such as the police asking you, "Did you kill John Doe?" Interrogation also might be less obvious, such as comments made by the police that they know are likely to elicit incriminating information from you. It is legal for the police to lie to you about what they know, or suspect, or what other people have said about you. So one of the common tactics is they will separate suspects or separate, members of a gang or separate whoever it is, co-defendants or witnesses or whatever. They'll put these 2 people in 2 different rooms and they'll play this game where they go in and out, in and out, in and out of the rooms, right? Door to door, and they'll say, "Well, Johnny said that you did it, man. He told us the whole story. So you better start singing." They'll start this with, "All right, we've got you in this room and we got Johnny in the other room. One of you is going to talk to us. It might as well be you, because whoever starts talking first, that's the person we're cutting a deal with. That's the person that's going to walk. One of you needs to start talking." "Oh, you don't want to talk? All right, I'm going to talk to Johnny right now." And they get up, they leave the room, they go talk to Johnny, give him the same spiel. Well, Randy is in the other room, and Randy's going to tell us everything there is to know. And then they go back and forth until finally they're like, "Yep, sorry, Johnny, but Randy already told me everything. He told me that you were in place X and you did Y and Z, and so on and so forth." And then Johnny, becoming indignant, will say, "That man, he's a liar. This is what really happened." And there it is, like magic. It works so often, you would not believe it. They're allowed to lie like that. Cops can say, "Yeah, Randy told us everything, man. Sorry. Good luck." And they know that it will get that guy to talk. Happens all the time. They're perfectly allowed to do that. So, tell me you want a lawyer. Don't answer questions. Don't talk to the police. Can't say it enough. The police may try to trick you into talking. This is one reason why it is so important to have a lawyer present during your interrogation. Look at that. ABA and I are on the same page today. Yes, Odysseus. When am I going to be done? In about 30 minutes. Okay? I know. It's a tough life, huh? Question: how do the police recommend that criminal charges be filed against someone? Answer: criminal cases go through a screening process before a defendant faces charges in court. This is a 2-step process that begins with the police inquiry. The investigating officer, or another officer superior to the arresting officer, will review the arrest report. That officer will determine whether there is enough evidence to recommend filing charges against the arrested person. If the officer decides not to recommend filing charges, then the police will release the arrested person. Yeah, that happens. If the officer decides to recommend that a charge be filed, a prosecutor from the district attorney's office, or here in Florida, the state attorney's office, will review the officer's recommendation. Based on the arrest report and any follow-up investigation, the prosecutor's office will decide whether to file charges and what criminal offenses to allege. An amazing article came out, I think it was late last week, on the state attorney here in Orlando, the 9th Judicial Circuit, where Osceola County Sheriff is complaining that this woman just keeps letting people go. How could she? These are criminals, and she's not prosecuting them. And her response was, yeah, well, the FDO, the Florida Department of Law Enforcement, their labs keep coming back saying there's no weight on these drugs. You guys keep sending quote-unquote drugs to Tallahassee for lab reports, and there's no weight to them. Like, these drugs don't actually exist. I'm not prosecuting these cases where there are no drugs. And the sheriff is up in arms about it. I mean, unironically, the best state attorney I've ever seen. Certainly here in the 9th Judicial Circuit. So, I mean, just incredible. Like, what seems common sense to a citizen, like, if there's no crime or if there's no evidence of a crime, you shouldn't file charges on it. The state attorney's actually, exercising that common sense. And the police are, of course, outraged about it. But that's the two-part process they're talking about. Police have the discretion to decide whether they're going to go forward with it. If they do, then they send it to the state attorney's office. And then the state attorney will decide whether to file charges. Actually, that's right. The ABA in this book has this whole page here, who exercises discretion. And it's this step-by-step process. Something I've complained about before. Hold on. Show your support for Augustus Invictus Esquire. Super sticker. Super chat. I can do a super chat? Ain't no way. All right. I expect everybody to be doing super chats now that I understand this is live. Show chat. So, here are the steps that they give. Police, prosecutors, judges or magistrates, correctional officials, and the paroling authority. I would add the jury in here myself, so we'll get to that. Police have discretion. Step 1, police have discretion on whether or how to enforce specific laws, investigate specific crimes, search people or areas, question people, and arrest or detain people. So one of the things I unfortunately have to tell people quite often is that the police have discretion on whether they're going to prosecute somebody. A lot of people are victims of crimes. Police can't possibly charge everybody. I mean, it's already a madhouse in this country. It's already a police state. But they will charge one party and not another. That rubs people the wrong way too. Police have discretion to do that. If one party does something wrong and both parties are bickering, a lot of times the other party, and this is not just domestic violence, I mean, this is just people in general, neighbors, disputing over, their kid getting an orange out of the neighbor's yard or whatever your dog pooped in my yard, whatever it is. Everybody wants to run to the police and say, you need to arrest this person. And the police have the discretion to say, no, that's a total waste of time. There's no evidence for this, and I'm not charging that person. Sorry. People get upset about that, but I think that's a good thing, right? The problem is when they abuse that discretion, right? And it's so dramatically obvious that it's a one-way street. It's not that they're abusing their discretion by not charging people with crimes. It's that they are so more often abusing their discretion by charging people with crimes who should not have been charged with crimes. It's a rarity, although it does happen, for cops to know that somebody has committed a crime and there is evidence of it and they refuse to prosecute or send it to the state attorney's office. It does happen, but I think everybody knows that the vast majority of the time they're abusing discretion is when they're saying, yeah, we're going to charge you with a crime anyway. We're going to send it to the state attorney. And if they don't think there's a crime, they'll let you go. happens on a daily, an hourly basis. Just you would not believe how often that happens. And this is where the process starts for passing the buck. And this is one of my biggest peeves with the criminal justice system, so-called. The police have the discretion to charge or not charge. They abuse that discretion by filing charges against someone that they know they can't prove the crime, or they know that there's problems with their case or whatever, but they'll send it to the state attorney or district attorney, whatever it is in your state. They'll send it anyway and say, well, it's up to the state attorney to decide what they're going to do with the case. Sorry. My obligation is done here. I wrote the arrest report. You're on your own. Good luck. If you're innocent, I guess they'll come out and the state attorney will dismiss your case. Here's the problem. Once that train starts, it's very hard to stop. So a state attorney will get a case, and they might know full well, yep, we don't have evidence, or, yep, there's problems with this case, or, yep, there's a lot of red flags here. This witness is lying, this alleged victim is lying, but, I have a boss, and the boss is telling me I got to go forward with this case, so at the very least, we're just hoping that we'll pressure this guy enough that he'll take a plea. Or at the very bare minimum, he'll enter into pretrial diversion or pretrial intervention, whatever it's called, where in your neighborhood. And that way, he won't have a conviction, but I also didn't let it slide. Right? Everybody wins. Win-win situation. Although it's not a win-win situation. Because an innocent person is going through a prosecutorial program to have his charges dismissed, where neither the state attorney nor the police should have gone forward with these accusations. Happens more than you can imagine. And here's the problem. Like I said, it's hard to stop that train from moving. Say the person doesn't get in the PTI. Say the person has absolutely no intention of taking a plea. It gets forced to trial. And the prosecutor, well, they've got a career. They've got face to save. They can't just dismiss the case. They've got a rabid person. We won't describe genders. We'll just say a rabid person, at their heels, like, I want to prosecute, I want to prosecute, I want to prosecute. They can't drop the case now. They got too much to lose. So they'll force it to trial, and they'll say, well, it's up to the judge. File a motion to dismiss. If there's no evidence, the judge will dismiss it. Based on probable cause, based on a motion to suppress, whatever you're going to do, file that motion, get it dismissed if there's nothing here. Otherwise, it's going to go to the jury. The judge will often use that out too. The judge knows there's nothing here. Prosecutor knows there's nothing here. Everybody in the room knows there's nothing. But they'll say, let's pass this buck on to the jury. We don't have any responsibility here. We're not the trier of fact. It's the jury. Sacred in America. Sacred, like the haruspects reading entrails of a sacrificed pigeon. We give things to the jury. And we say, this sacred body of august citizens, they will know what to do. They will discern the facts and know what really happened here. Laughable. But everybody wants to pass the responsibility on to the next person. Police pass it on to the prosecutor. Prosecutor passes it on to the judge. Judge passes it on to the jury. Well, the jury, they have no responsibility whatsoever, because no one can ever question them. No one can ever interview them about how they came to their decision. Their decision is final. It is sacred. It is a divine oracle of innocence or guilt.
Daddy, I got a toy.
Very nice, buddy. Go play with that toy, all right? So once you start that train of, let's pass it on to the next person, let's refuse to exercise our discretion and put it in the next person's hands and let them exercise discretion, it's a slippery slope that leads to a lot of false convictions, a lot of destroyed lives, destroyed families. So if you're a cop or a prosecutor or a judge or a prospective jury member, please take this into account in the future. They continue with correctional officials and paroling authority. Correctional officials have discretion to assign convicted people to correctional facilities, award privileges, and punish prisoners for disciplinary infractions. So a lot of unfortunate cases where the jail is messing with an inmate, or whether it's pretrial or post-conviction, jail personnel or prison personnel will mess with somebody, or they'll move them to the wrong facility, or something goes wrong. And you often got to tell people, I'm sorry, but there's nothing the trial court can do about that. That's an administrative matter now. Something happens at the AdMax in Colorado, it's not like you can go to the San Francisco District Court where your case came from and complain about it. Like, that's now a BOP issue. You're going to have to sue the Bureau of Prisons. So the corrections system is another beast that I'm not even going to get into in this episode. And then there's the paroling authority, whether you got probation or parole after your prison sentence or in lieu of a prison sentence. Not that it matters, but that's a different area. And they exercise discretion, mostly in did you violate your probation, the terms of your probation or not, right? So somebody leaves the county or something and didn't notify, or I don't know, drug tests coming positive, that's usually they're going to go on that. But there are some minor violations or technical violations that a PO might say, yeah, I'm not going to violate you for that, just don't do it again. But I am not telling you to bank on that. I'm telling you should assume that they're going to violate you for everything. So do not violate the terms of your probation no matter what. You have no idea how many VOP cases I've had where it's just some stupid misunderstanding. Should have told the PO that you were going somewhere and you didn't, or, I called them and I left a voicemail, and I'm like, well, did you leave it in an email? Is there any writing? Nope. Well, then it's the PO's word against yours, and the judge is almost always going to go with the PO. Now, unless you got hard evidence or a witness or something really strong. So just do the safe thing and don't violate your probation. I think that's the lesson for today. Lawyers and criminal law. Question: when do I have a right to a lawyer? Before or during police interrogation? Answer: you have a constitutional right to counsel, the right to have a lawyer's advice, before and during police interrogation. If the police are asking you questions and you think they may think you are involved in a crime, you think they may think you are involved in a crime, tell them that you do not want to answer questions and that you want a lawyer, regardless of whether you have been given Miranda warnings. Yeah, don't try to game the police, right? Oh man, I've had so many cases, a lot of times drug cases, where, the suspect or defendant turns out to be, thought that they were going to just talk their way out of it, or like game the police, or, convince the police that they were stupid, like the police were stupid and that they just didn't understand, or that there was somebody else to blame, and they'll try to just game their way out of it. Don't do that. Certainly don't base your game on whether or not you were read your Miranda rights, because some people, like we talked about earlier, are you in custody or are you not in custody? I don't know. It depends. So don't bank on what a judge or a jury are going to think about you being in custody or not while you're playing some game of semantics with the police. Just shut your mouth. Just don't say anything. Problem solved, right? Police frequently obtain damaging admissions before you are in custody and prior to providing Miranda warnings. Do not answer any questions until your lawyer arrives. For perhaps the first time in history, I am in 100% agreement with the ABA on this one. Do not answer any questions until your lawyer arrives. If the police place you in a lineup, the law entitles you to have a lawyer present if you have been formally charged. You also have a right to a lawyer at all your court appearances. Although, if I may, fellow members of the legal profession. This has become such a hollow right that it's worth commenting on. You have a right as a defendant to be present at all of your court appearances. You have a right to have a lawyer present at all of your court appearances. That's the law. However, it's become a hollow right in that you're just allowed to show up and get railroaded. You're basically just there to watch yourself get railroaded, especially during COVID and the aftermath when there were Zoom meetings and the lawyer and the defendant were not even in the same building, much less the same room. They couldn't speak to each other. The witness is basically, the defendant is basically just there as a witness to what the volley is going on between these lawyers and the judge. Can't even talk to his own attorney, right? Or so many times where there's no input allowed whatsoever from the defendant, and that's not the lawyer's call. It's just there's nothing to be done. Oh, your motion wasn't scheduled for hearing today. Oh, sorry. Come back 2 months from now. While you sit there without bond, your life being destroyed the whole time. Hopefully by that time you'll be smart enough to take a plea and we can forget about the hearing, right? Doesn't matter if you did it or not. What we care about is judicial efficiency. So this right to be present at your hearings, the right is so that, yes, you know what's going on, but also so that you can be involved in your defense. It's not just to sit there watching them disembowel you in a public courtroom. It's so that you can be involved and you can help your attorney and you can defend yourself. A lot of lawyers and judges have forgotten that fact. They think this is just a box to check off so you don't get appealed. It's a box to check off so you don't get a motion for post-conviction relief filed against you. It's just something we do because that's the law. These inconvenient things that we got to do for people. And they forget that the whole system is based on it's better to have a guilty man go free than to have an innocent man locked up. And so many lawyers and so many judges don't want to take a look at the fact of how many innocent people we lock up on a daily basis. Question. If the police arrest a friend or a relative, may I send a lawyer to the jail to offer help? Answer. Yes, but the right to counsel is personal to the accused. This means that the person who is under arrest must tell the police that he or she wants a lawyer. In some states, if your friend waives the right to counsel and agrees to talk to the police do not have to tell your friend that you are sending a lawyer, right? Or in some states, if your friend has not requested a lawyer, the police are even permitted to turn away the lawyer upon arrival at the station without telling your friend. Thankfully, that's not Florida, right? If the lawyer shows up in Florida to a jail or a prison, the police are, they're going to let you in, no matter what time of day. That's a right. If the lawyer shows up and says, "This is my client, I'm here to see him," they're going to let you in there. Shudder to think of the states that don't allow that. If a friend telephones you, the best thing you can do is say that a lawyer is on the way to offer help. Your friend should tell the police that he or she does not want to answer questions until he or she has had the opportunity to talk to a lawyer. So let me translate that. If you, Aunt Martha, your nephew, Jimmy Boy gets arrested for vandalism, or whatever it is, you don't know. All you know is that the cops have taken your little nephew away. You, Aunt Martha, immediately call a lawyer right out of the phone book, and you say, "Mr. So-and-so, my nephew's just arrested. This is an emergency. I will pay you $1,000 just to go talk to him right now before he says anything to the police." Well, during the time this transaction is taking place, Jimmy Boy says to the police, "Yeah, I got nothing to hide." He has no idea that Aunt Martha is hiring this attorney. No idea that there's an attorney on the way to talk to him. And he says to the police, "Yeah, I got nothing to hide. Whatever, man, I'll talk to you." Gives an hour-long, essentially, confession of what happened. He doesn't know it's a confession. He's just talking shop with these guys. He's got nothing to hide. Lawyer shows up. It's too late. Jimmy Boy never said he wanted to talk to a lawyer. It was Aunt Martha who sent him. Aunt Martha has no rights. Aunt Martha is not the accused. Jimmy Boy is the accused, and Jimmy Boy waived his right to counsel. Frustrating for Aunt Martha, but it's not Aunt Martha that's standing trial. It's Jimmy Boy who wasn't paying attention to this episode. Question: how do I find a lawyer? Answer: if you have a family lawyer, call him or her immediately. If your family lawyer does not do criminal work, he or she may be able to recommend another lawyer who does. Oh, boy. Let me tell you this one. Do not hire an employment lawyer to do your criminal case. Right? Do not hire your workers' comp lawyer to do your divorce and custody case. Don't hire me to do your workers' comp case, right? Your criminal and family attorney does not know workers' comp. 99% of the time. I'm going to refer you to someone else, right? I've had cases in the past, that is, where there are cases I do not do, and I tell them I am not taking your case, and they have kicked in my door and made me take their case. That happens, and sometimes it's, you're the only attorney they will hire. I've had that several times in my career. But generally speaking, you want a criminal lawyer to be doing your criminal case. I don't care if it's DUI or vandalism or murder. If they don't know criminal law, do not hire them to do your criminal case. That is a hard and fast rule I'm going to put down right now. Totally different set of rules. Whereas you might get, sued in a contract case over ice cream, and maybe your criminal or family attorney could take that case because it's, a no-brainer, and they learned that stuff in first year of law school. Conversely, that is not the case. Like, all lawyers are required to take criminal law their first year of law school, at least to my knowledge, in every state I know of. But that does not mean that your lawyer knows the first thing about a criminal case in real life. So, like this is saying, if you have a family lawyer, call that person, but if they don't do criminal law, ask for a referral, all right? Don't gamble away on it because your Uncle Jeff is a corporate lawyer. Good Lord. I mean, can't tell you. I've seen it. Don't be that person. Question: what should I tell my lawyer? Well, like we said last week. Answer: you should tell your lawyer the truth. Let me repeat that. You should tell your lawyer the truth. Your lawyer has to know exactly what happened in order to defend you effectively. Tell your lawyer as many details as you can remember. Anything you tell your lawyer is confidential and will be kept secret, unless it applies to any continuing or future crime. The law refers to this as the attorney-client privilege. Your lawyer has ethical obligations to you as the client. However, a lawyer also has an ethical obligation to the court. A lawyer may not lie to the court for you or knowingly offer a false defense. So that's why a lot of people think, I'm just going to lie to the lawyer, because he's not going to tell the court and the prosecutor my side of things, my side being the lie, if I don't lie to him. If I tell him I really did kill Sally, he's not going to say that I was at the bar down the street. I have to lie to the lawyer. And, he's going to put on the defense that I wanted to put on. He's only going to see what I show him. That is stupid, because you have no idea yet what evidence the other side has. And it's not hard for a lawyer to figure out that you are lying, first of all. But more importantly, you don't want your lawyer getting blindsided in court by something you lied to him about. It's just bad politics, for one. Like, the one guy going to bat for you, you just made him look like an idiot in court. That's not smart. But also, the judge is going to know that your lawyer was blindsided by the look of shock on their face or by the stupid questions coming out of the lawyer's mouth. This has happened to me, as you can imagine, when I was a young man. and I did not take kindly to it. It's a stupid path to go down. Don't lie to your lawyer thinking that lying to your lawyer is going to do you any favors. It's not. It's going to sink both of you, and it's not a ship you want to be on. In practical terms, that means that if you tell your lawyer you did not commit the crime but were present when it happened, your lawyer cannot bring in alibi witnesses who will testify falsely that you were with them in another state when the crime took place. Right. If you tell your lawyer that you did commit the crime, he or she is limited in the way she can present the case. Which is not to say lie to your lawyer or tell them you did not commit the crime or just don't say anything to your lawyer at all. What it's saying is, a lot of people have this idea that lawyers are liars. I don't know how they get that idea, but they have that idea, and they think, well, the lawyer's just going to say whatever I tell them to say. Like, that's their job, right? They lie for a living, right? That's what the media says, so that's what we think of lawyers. It's not actually the case. Lawyers are officers of the court, and they cannot present, they're not allowed to present false testimony, although can't tell you how many times I've seen it happen. A lot of times from prosecutors who know that what their witnesses are saying are lies, but we are out of time, so we're not going to go down that road today. We do have, so we could do a 4-part series on this. We'll see whether we're going to do part 3 next week or whether we're going to talk about the news. I don't know. We are done. We're saying goodbye right now. You ready to say goodbye?
Yeah.
Yeah. All right, so bye-bye. Until then, stay in school. Don't do drugs. Do not talk to the cops. And don't lie to your lawyer. See you next week, everybody.